The defense wants your case thrown out. They don't want to go to trial, but instead they want to have the judge throw your case out before you ever get to trial. You want to find out what this is all about and why they're asking the judge to throw it out and what it means for you and your case? Come join me on this walk through the neighborhood as I share with you exactly what this is all about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. Now, all the discovery on your case has been finished. Now your case is technically ready for trial. So your attorney advises the court that your case is now ready for trial. Okay, you think that's great. Now in maybe a few months you'll get a date to come in and start your trial. Well, no, before that happens, the defense decides they want to take another shot at the apple and try and get your case thrown out. They don't want to run the risk of going ahead and going to trial not knowing what a jury may do. So now they're going to go ahead and say, hey, judge, we don't believe this case should ever get to trial. We don't think a trial is warranted here, and in fact, we don't think this case has merit at all. We don't think Oginski's client has a meritorious case. We want you to throw the case out before ever getting to trial. Can the judge do that? Can the defense attorney do that? The answer is yes, they can do that. They can make that request. And yes, it is possible that the judge could turn around and decide, hey, after maybe 2 years of discovery and prosecuting your case, the judge may determine that yes, you do not have a meritorious case. So what happens when the defense asks the judge to throw your case out? I'll tell you what happens. What happens now is that you actually have to have a trial. Now, you might be saying, wait a second, the defense doesn't want a trial. So how is it that you could actually be having a trial in order for the judge to make a decision? I'll tell you how. It's a trial that is done on paper only. Now, what does that mean? Okay, so here's what it means. When the defense asks the judge to throw your case out, what they are doing is that they are making a formal request to the court that says, hey, judge, listen, we don't believe that there are questions of fact for a jury to evaluate. And because of that, there's no need for a trial. Because there are no questions of fact to evaluate, there are only issues of law. And judge, you are the one who decides these issues of law. And you should see, based upon our supporting documents and the experts' documents that we have submitted in support of our request, that there is no possible way that the plaintiff, the injured patient, has a valid and meritorious case. So that's what they are trying to do. Now, in response, what do we have to do? In response, we have to turn around and literally have a trial, but it's done only on paper. So instead of bringing witnesses in to testify, to swear to tell the truth, instead of going ahead and have certain documents admitted into evidence, we have to do the same exact thing. We have to obtain all of our evidence. We have to now prepare papers. We have to get our experts to come in and now, on paper, explain in exquisite detail exactly why we believe we have a valid and meritorious case and why the defense's arguments are totally wrong. What we really have to show the court in exquisite detail is why there are clear questions of fact that have to be answered. If we are able to show the court that there are significant material questions of fact that have to be answered, then the judge will have to deny the defense's request. That's the issue. You see, the judge is not the fact finder of the case. If there are questions of fact about who did what and whether something was appropriate or not, and now we have competing medical experts who give differing opinions about what should or should not have been done, that raises significant questions of fact. In that instance, the judge is not the one to make the decision about whether your case is or is not meritorious. Instead, the only decision for the judge to answer in this request to throw your case out is whether there are significant material questions of fact that a jury is to resolve and not the judge. So legally, this is all known as the defendant making a motion, which is a written formal request for summary judgment, which means they want a judge to summarily give them a decision in their favor without the need for ever getting to trial. We, on the other hand, now have to go ahead and put in documents, put in papers that go ahead and explain why the defense is wrong, have our medical experts explain in detail exactly why there are significant material issues of fact, about things that happened in the hospital record, about testimony that has been given during the pretrial process, about evidence that we have obtained. And now, once we are able to show that, we submit it to the court, and then the judge Sometimes we'll have oral argument, so now the attorneys can present their arguments, and together with that information, now the judge will go back, read those papers, and ultimately make a decision. So why is this a big deal? It's a very big deal because the defense is hoping that they are going to get your case thrown out before ever getting to trial. They're hoping that they have one last-ditch effort to go ahead and get your case dismissed without the need to invest in getting medical experts to come in and testify, without the need to having their attorneys go ahead and prepare the case for trial, without the need to go ahead and have a prolonged, protracted trial. The defense is hoping that they will get the judge to side in their favor and recognize that there is no factual issue to decide, and in fact only legal issues to decide, and that there's no meritorious case. We, on the other hand, want to show something totally different. So why do I share this great information with you? I share it with you because nobody really talks about this. It's so critically important to understand that if you are deciding whether or not to bring a case, and now your case goes through the litigation process, you believe that at some point you're going to have your day at trial. You're going to be able to present your facts, your case to a jury. Well, that's the intention, and that will happen during the course of your entire litigation. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and are thinking of doing so but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.